The FTC has a health breach notification rule. So where HIPAA kind of falls off because you have to meet two primary criteria to have HIPAA data, the FTC can pick it up. So it's more or less health data, and they take an expansive view of what health data is. It's an interesting study over the last 24 months. So they've been using Section 5 of the FTC Act to bring enforcement actions against websites or web applications with respect to the collection, use, and sharing or disbursement of particular data. So there's a number that have gotten a lot of attention on the internet. For example, one website could be used to track you and whether or not you're going in and out of certain healthcare clinics. Subsequent to those enforcement actions, which a lot of us kind of scratched our head at, thinking, well, I'm not sure this is exactly what these laws or regulations have been intended to regulate. The FTC went through a rulemaking process, in effect, looking to expand the scope of their regulatory authority to cover what I would argue would be the enforcement actions that they just resolved. So they enforce and then through rulemaking expand. Depending on where you sit in the world on whether you think regulation is good or bad, it does make you wonder, are we in a world where, because the legislative process is somewhat broken both in states and in Congress, are regulators looking or having to interpret their own scope of enforcement capabilities to apply to these new technologies, including AdTech, but also to apply to uses of data through AdTech technologies. And the FTC's little case study there over the last 24 months would say at least one regulator, a very important and powerful one in Washington under the current administration, we'll see what they look like under the next administration, has followed suit. But right now, working into the next administration, we're all kind of leaning and wondering what's gonna happen with respect to this rulemaking and what's gonna happen with respect to that particular agency's authorization in this space. I think we're going to see that repeatedly, whether it's a Republican or Democratic administration in your state or in Washington. On the litigation side, just quickly, why do we attend to all of these things? Well, we attend to some of them because they present a lot of risk, and whether or not your organization is going to be in the crosshairs of plaintiff's counsel or a consumer who doesn't like what you're doing on other things and is going to use this as a lawsuit. We have seen a massive upswell in the last 3 years of all kinds of privacy-inspired litigation. So Illinois' biometric law, which has kind of, I think, probably still leads the day in some of these litigations. On any given day, there's often about 200 plus lawsuits pending in Illinois under their BIPA. This is the collection and use of biometric data. Compliance with BIPA is actually relatively straightforward if you read it, but it's complicated by how businesses use biometric data. If we take those lessons and apply them to other things like wiretapping lawsuits in California, Florida, and Massachusetts and Pennsylvania, where plaintiffs' lawyers are taking laws that really originated out of the 70s and then the 80s. These are the same laws that we talk about in the show Law and Order. Same wiretapping statutes, often criminally focused. And they're applying those to website technologies like AdTech to say, well, you didn't adequately record or collect my information in violation of the state wiretapping statute or the federal wiretapping statute. And we'll talk in a little bit about things like consent and what I call the get out of jail free card of consent. But plaintiffs' counsel and litigants have been very thoughtful in navigating old laws, applying them to new technologies. We've seen this repeatedly, and wiretapping is just one example. And then the final point, something that happened in New Jersey, there was a privacy statute that came on. It was a sad story. Federal judges was targeted for assassination by criminals, opened the door, and they shot the wrong person. They shot the judge's son. It's called Daniel's Law. Daniel's Law was amended in the last couple of years with some kind of cavalier and thoughtful folks who wanted to expand the scope of it. It's now being used to bring over 100 lawsuits with respect to the collection of private information related to law enforcement officers or correction officers in alleged violation of the statute. Interesting there is you have folks who allegedly invested a lot of time and energy in developing a law that could be used for lawsuits. And so we're seeing folks take positions on the privacy side of the plaintiff's bar to pursue kind of new theories with respect to the collection and use of technology through websites. So kind of a cascading and increasing level of risk, Val, that we see. And I don't think that that's going to change regardless of the administration or politics in your state or in Washington.
Yeah, I think the wiretapping stuff is sort of fascinating because of that cross section, right? The Nixon era wiretapping laws being conflated with, modern tracking technologies and not at odds with, but sort of butting up against things like CCPA and other laws. And I think that's exactly where plaintiffs bars and others are sort of capitalizing is how are courts going to decide. And courts have been split, right, Scott? I mean, that's sort of what we've seen so far is that courts have been split on wiretapping decisions and settlements.
Yeah, what we've seen both in state and federal courts is the details matter, and the details also will incentivize or disincentivize the folks who are pursuing these lawsuits. So, for those organizations who aren't paying attention or are trying to completely kind of dissolve themselves of responsibility for data collection through AdTech, they're having more problems than those organizations that kind of, have the warning signs up and have done all of their diligence on what they're doing. They're having a much better day in court, in our view.